to kill Wilson to satisfy, remember we have an attempt here, to satisfy the intent requirements for attempting to kill the passengers. Somebody other than Mr. Webb, since this is a crime of attempt, what are you going to tell the jury on the defense side? You're the defense lawyer. Mr. Webb can't be both. That's a conflict of interest.
You can't attempt second-degree murder because it's a crime of recklessness, and so there's no.
But what are you going to say about your client's intent?
He didn't intend to kill the two passengers.
He didn't intend to kill the passengers, and you're going to and how do we know that? Or what argument would you make to support that?
They weren't the target. They aren't.
Who was the target?
Wilson.
Now that's a problem for you, obviously, right? Because you don't really want to tell the jury that he intended to kill the person he killed, because now you've got the murder conviction. But at least you might limit it to that. So you're going to say, ladies and gentlemen of the jury, even if you conclude that my client intended to kill Wilson, you cannot find that he intended to kill the passengers because he was indifferent as to them at worst. Maybe that was reckless, but he didn't intend to kill them. And you can't rely on the fact that he intended to kill Wilson to kill the passengers. You have to find specifically that he intended their deaths, and there is simply no evidence of that. Okay, so that's what the defense is going to argue. You can't rely on the transfer intent, and there is no other evidence of actual intent directed at the passengers. Okay? And the Court of Appeals says, yes, that's a problem. The trial court relied on transferred intent, the verdict relies on transferred intent, and that is no good. Yes, you have to have intent, because attempt is the crime, but this won't satisfy it. There has to be actual intent. What did the California Supreme Court say, Mr. Webb?
Well, they wouldn't for a long time. They agreed with the Court of Appeals that transferred intent doesn't apply to attempted murder for the most part. They did mention things about kill zones, so there's like a kind of a caveat there, like if you did that.
We're going to talk about kill zones and how that ends up saving the prosecution's butt.
But then inevitably they just say that the court correctly answered the jury's questions, and that it's, the appeal was based on the jury being instructed wrongly about transferred intent, and they basically say that's not true. They were instructed fine. They weren't instructed incorrectly, and so therefore the conviction in the trial court is
So if it's not on a transferred intent theory, tell me about this kill zone theory.
So kill zone is like if he intended to kill Wilson, but to do so he had to create a kill zone, an area, he was kind of like almost protected by two people he didn't intend to kill. And so he had to kill everything in that area.
He didn't intend to kill? What is a kill zone theory? How does it relate to Bland's intent?
So like if say like you use a grenade to kill someone. If you're using a grenade to kill someone, you intend to kill everyone in that area, even if your specific target was one person.
If defendant creates a kill zone, the jury can find that she intended to kill everyone in that zone. Why? Or what is essential to the kill zone theory? What's essential or inherent in the kill zone theory?
That the person was aware that those victims would die.
Why? Why would that be true? We heard this grenade example. What is it? What does that tell you?
It's foreseeable.
Foreseeability is not quite intent, though.
You intend to kill that person, and so you intend to harm everyone around that person.
if I, what's the difference between the situation in which Wilson kills Bland by poisoning his cocktail and Wilson kills Bland by spraying bullets into the bar where Bland is drinking that cocktail? What's the difference?
Would it be that he like disregards like we'll do the act, we'll throw the grenade regardless
The,
of whether or
the
not there's
poison versus the spray of bullets. Think much more simply. What's the difference?
So there's a difference between one specific target. They talk about how holding a gun to one person's head, like you're only targeting one person versus the entire group of people.
Sniper shoots one shot versus grenade. What am I differentiating in all of those situations?
You're differentiating the sort of area that's affected.
Not an area that's affected, no. What, I got lots of hands.
I feel like it's kind of driven to make a single person realize if you throw a grenade, a bunch of people are gonna get hurt, so if you only.
Why? Why?
Because it's gonna like explode.
What am I differentiating here? What am I differentiating here? Very simply.
so the accuracy,
What?
the accuracy
Of what?
of the
These are all about the means. Kill zone is about the means. Right? This is how you did it. And with the kill zone, it's not enough, at least the theory is, it's not enough that the means that could create a kill zone were reckless as to killing the others, but that that's actually what you intended. That you could not have intended anything else when you chose that means, right? That you intended, if you use a grenade or if you plant a bomb on a plane, let's say you're trying to kill your ex-spouse who's on that flight. But if you plant a bomb on that plane, because you've chosen a means that inevitably would result in that outcome, that you that you did intend, and the jury at least could find that you intended to kill everyone on that plane, or everyone who was within range of that grenade. You don't have, so as long as you intend all the people within the zone to die, you can be said to have the required intent. Okay? So we're trying here not about transferred intent, but what the courts calls concurrent intent. You intended both to kill Bland and anyone else in the kill zone. So that's where we get the intent. Lyerla tells us you have to have intent, and Wilson gives us, Wilson gives us a specific, I don't want to say exception, or a specific context in which we can find intent, somewhat unusual circumstances. Okay? Now, everyone see that?
So, I'm just making sure that I understand the overall concept here. The means is enough, depending on what means you use to establish the kill zone, that dictates who you intend to kill.
No. If you use a means that, it's not what means you use to create a kill zone, it's that you use means that created a kill zone at all.
Okay.
Right? This means doesn't create a kill zone. This means one shot by a sniper doesn't create a kill zone.
Okay.
So you can't, if it turns out that the poison kills more than one person, because maybe Bland shares the cocktail, right? In that situation, putting poison in Bland's cocktail wouldn't result in a kill zone, because the means is not calculated to do that. This does create a kill zone. So if you created a kill zone, jury has to find that, right? Prosecution has to have that as its theory. You're not using some sort of transfer of intent. But my question about that is, isn't it odd that you could affirm the conviction here? the California Supreme Court says, we're gonna reverse the Court of Appeals and reinstate the conviction, even though this jury was never told that it had to find that a kill zone had been created, and that therefore that was the basis for their finding of an attempted murder conviction. I think it is, the California Supreme Court here goes out of its way to pretend that the jury was told something it never was, as what it had to find in order to convict him. Right? Because the answers to the jury's questions only talk about having to look at the separate counts separately. That's not telling the jury that in looking at those separate counts, it needs to find that he created a kill zone and thus can be convicted of attempted murder of the passengers. So in my view, while I get the law here, its application in a situation in which the jury wasn't told correctly that that is the law, that they must find a kill zone to find intent, that this case should have been sent back for a new trial. And then with the jury told that, and then see what they find. Yeah.
How did this get to the Supreme Court? Because to me, it sounds like the prosecution raises this review, and if the appellate court told them to go back to trial, how did they, like?
Because then who appeals that?
Well, I didn't know that the state could appeal it.
They can't appeal a not guilty verdict. But if they get a guilty verdict, and let's say the trial court overturns the jury verdict, or if the Court of Appeals reverses the verdict, right, then the state can appeal that. The thing they cannot appeal is a not guilty verdict. At that point, the case is over. But if they got a verdict, pro-prosecution verdict, and for some reason the Court of Appeals says, no, we gotta throw that out, evidentiary ruling, jury instructions were bad, then they can appeal to the next highest court and say, no, the trial was good. The verdict was supported, the verdict was valid, reinstate the guilty verdict. Okay? Anything else? Okay, that's all we're going to do on mens rea of attempt. And now we're going to talk about the actus reus of attempt. And here is pretty much our first encounter, certainly our first in-depth encounter with the idea of eras of the law. Because the rule, as you will see as we go through this whole issue of what constitutes the act of attempt, what's enough for attempt, the law has changed significantly from the common law rule, the common law approach to this issue, versus the modern rule, right? So we'll begin with the common law rule, keeping in mind that we're doing this for the purpose of contrast, and this is not the way the law works today, okay? The question we're asking is, how much does a defendant have to do towards completion of the offense for it to count as an attempt? And you can think of this as a timeline, or if you like, when the timeline begin, when does the timeline towards an offense begin? What would be here? What? No, an timeline. Not a element line, a timeline. Right? Or if you like, what's here? What's at the
When
end
they commit
of our timeline?
the end of the act, after they committed the act?
The crime.
Yes.
Right. The completed crime is here. Right? And so what has to be at the very, very beginning?
The idea.
Smith?
Preparation of the crime?
No, before that,
The idea?
the idea, the
I
mere
believe that.
thought. Now, how many of you think that we should be able to state the government should be able to punish for mere thoughts? Punish you for attempt, for just thinking? How many of you have ever thought of committing a crime? Right? Any of you who have siblings and have thought, I'm going to kill my sister, brother, right? Right? You thought of it. I mean, the thought probably wasn't serious, but you thought of doing something that was criminal, right? So we certainly don't want to punish mere thoughts. At at some point along the way, what might we fill in along this timeline?
Substantial steps.
Steps. Like renting a building towards opening a speakeasy. Remember that?
Mhm.
Yeah.
So like might be acquiring things. It might be soliciting accomplices. Okay? It might be traveling to where you need to go to commit the crime. You can think of all sorts of steps along the way, and eventually we get to a bank robbery. Eventually we get to a murder. And the question is, at what point along this way do we say, aha, we've crossed the line to attempt? This stuff back here is what we call mere preparation. If it's on this side of the line, it's mere preparation. If it's on this side of the line, it's attempt. And the question we'll be asking ourselves is, where is that line? And what definition should we use to draw it? What definition? So what was Murray charged with attempting?
He was charged with attempting a contract and incestuous marriage with his niece.
Attempted incest. Attempted incest. And this just so what evidence, what does the evidence show he did to bring about this incestuous marriage with his niece?
He only had, so the only thing they could prove is that he had declaration.
He declared his love, his intent to marry her. Okay, so we have a declaration. What else?
His request to one of the witnesses to get a magistrate to perform the ceremony.
And his elopement with the niece.
Yeah.
And that meant, in the terminology at the time, he took off with her. Right? He absconded with his niece to go get married. All right? And he asked a witness to go get a magistrate. Given these things, here's what I want to do. Let's go do it. And now let me get the person I need to perform it. Where on this continuum between mere thought, forget these specific steps I listed, but between mere thought and the completed crime, where on the continuum would you place that? Like, is that here? Is that here? Is that here? Is that here? Obviously, it's not the completed crime.
Well, the court said it was.
I don't care what the court said. I asked you.
I feel like it's pretty close.
I feel like it's pretty darn close too. Right? He pretty much did everything in his power to bring about this illegal marriage. The only thing he was missing was the magistrate, and he had sent for the magistrate. So if you do everything in your power, that's pretty darn substantial. Our friend Murray took some darn substantial steps. Do you have any doubt that he intended for this to happen? Anybody else doubt that he intended to bring this marriage about? Okay? So he's guilty of attempt. No, he's not guilty of attempt. Why does the California Supreme Court say that these steps are not enough to constitute an attempt?
They said that his steps were preparation, not attempt, because the attempt is the direct movement towards the commission after the preparation.
That's the ultimate rule. Were they, you said you were convinced, and no one else disagreed with you, that his intent was shown. Did the California Supreme Court disagree with that?
Yeah, they said.
They did?
Oh, no.
Where in the opinion, you can search high, you can search low. You can search far, you can search wide. For the California Supreme Court ever saying the reason for the rule we're creating is because any other rule would leave doubt as to intent. The rule in California, the common law rule did not depend on doubt as to intent. The California Supreme Court and other courts that have this same rule, the mere preparation rule, didn't have this rule because they were concerned that intent wasn't shown. This case illustrates that because the intent is evident. It's merely, the court is saying, so what? That's not enough. There has to be more.
Yes, are they drawing the intent line at an act that will directly lead towards completion? So even though he's taken all of these steps, if he stopped at those current steps, he wouldn't actually marry the niece. It would be different if he were like standing at the altar.
That's what they say. He needed to be at the altar about to take the vows. He needed to be right here.
That's ridiculous.
He needed to be at the altar. And that was the common law rule. Dangerous proximity. It was called, and we'll see that, the dangerous proximity test. You must be so near to completion. And that's the common law rule. Dangerous proximity. He had to have been ready to take the vows, standing before the magistrate, appropriate to the contract of marriage. Okay? And the Model Penal Code drafters rejected this rule. And they decided that the right test is simply that the defendant must have taken a substantial step towards completion of the offense. And we measure substantiality by whether or not there is the step that is used, the step the prosecution tries to point to, is strongly corroborative of the criminal purpose. So while the dangerous proximity test makes the intent irrelevant and measures it by how close you are to completion, the substantial step test says, let's measure from how far you've gone from here. And have you gone far enough to corroborate your criminal purpose? If we have doubts, like you've only had thoughts, or you've taken a step like owning a building that is consistent with both innocent and criminal purposes, that doesn't corroborate criminal purpose. So the prosecution must prove to a jury beyond a reasonable doubt that whatever step they have taken, the defendant has taken, it corroborates that, aha, that's a criminal purpose. So we're asking, how far in this direction have you gone, and does it corroborate criminal purpose? That's the modern test. The dangerous proximity test doesn't focus on corroborating intent, and it doesn't focus on how far you've gone from here, it focuses on how close you got to here. Everyone see that difference? And we'll talk a lot more about this next Monday. But that, I want to just lay out the basics.
Dangerous proximity is what they use in Murray's case, but
Yes.
for like present day, they would use the
Substantial step.
Did you just say substantial test one more time?
The substantial step test is, has the defendant taken a substantial step from here towards the crime, and we measure whether it's substantial based on whether it strongly corroborates criminal purpose. Okay? Again, we will talk about this a lot more on Monday.